Hi, everyone. Harry here to talk about the Supreme Court's decision to hear a very controversial and complicated case involving mifepristone, the drug that in combination with another is used most commonly. I think over 50% of the abortions in this country use this combination of drugs. The first thing to note, the Supreme Court's weighed in. It's abortion, first time since Dobbs. But the legal question here really is not about abortion. It's an administrative law question. So to set this up, over 20 years ago, the FDA approved this drug and the so-called cocktail of two drugs, including mifepristone. One basically puts the mother's body into miscarriage mode, and the other actually terminates the pregnancy. It approved it as safe. And indeed, ever since then, it's been used widely and very safely, and is, as I say, the most common technique for abortions in this country. That's why, in fact, it's such a roiled issue, because this, in addition, it's if you're able to get the drug, say, through the mail, as some states permit, you can bypass the regulations. Even if abortion is illegal, it's a way to do it that would make it, very hard for the state to intrude. And as I say, it's the very common procedure. So it's one that, abortion opponents really have their sights set on. Okay, but why is it not an abortion issue? Why is it really an administrative law issue? Because what's at stake here is decisions that the FDA made later in 2016, I believe, and 2020 to expand the use of mifepristone, having found that, to expand it in a few ways. First, to let it be used later in pregnancy, I think from 7 to 10 weeks. And second, to permit it to be used when healthcare providers, but not necessarily doctors, prescribe it. So that really widens the field. And there is also the hovering issue of availability in the mail. All right, so this case starts, and you'll be hearing about it with a very pro-life district court judge in Texas, Kaczmarek, and he, makes rulings that are, extremely dubious, and he reaches out for them. But the short point for now is all of that pretty much goes by the boards, but it goes from him to the Fifth Circuit, which reverses in part, and then to the Supreme Court, which enters a stay, so that the state of play is that mifepristone is as available as it was, before Kaczmarek got involved, and then it goes back, but only part of it. All of that is really beside the point now. And what the point is the administrative law issue. So what are the challengers saying? They're saying that the FDA, even though it's been very safely used since it was approved, and including very safely used under the new conditions, the healthcare providers rather than doctors, and the later in pregnancy. Nevertheless, say the challengers, the FDA didn't have an adequate factual predicate to expand the use. It was, in the words of the law and administrative law Horn book, arbitrary and capricious, meaning they were just kind of, going for it without a good enough administrative record. And technically, that, if that's true, and the Supreme Court adopts that claim, it would be invalid for them to have done, even though it's crazy in a sense and kind of a topsy-turvy Alice in Wonderland claim, because in fact it has been solid, and the reasons you would have review for arbitrariness and caprice is because you're worried that they would make bad decisions. So there's this hovering point that, everything's worked out fine. But, there's no stone that goes unturned by pro-life, strong advocates trying to undermine the use of abortion. So there's, this is the claim that the FDA didn't go through all the steps it should have when it expanded the use. All right. Now it goes to the court, which has already granted a stay. You would think, anything involving the A word is going to roil the court, etc. But this, involves a different A word, administrative law, which, by the way, the resident expert on the Supreme Court is none other than Justice Elena Kagan. And you would think that the court would be, level-headed and rational enough to say, whatever may be wrong with this drug or whoever objects to it for other reasons, the FDA didn't screw up. They had enough there to expand the use. And by the way, even though it's in some technical sense beside the point, it's all worked out. It would be a little bit of a strange fiction. The law can do this sort of thing, but to say, it was wrong or they didn't have enough to go on in 2016, even if it did work out. So, I think, and also the opinion below by Kaczmarek is really extreme. It's known to be extreme. So this might be a case in which the Supreme Court, quote unquote, it allows or reverses on abortion rights, and that would be the headline. We shouldn't be fooled by that headline. It doesn't, it's not a counterweight to Dobbs or anything like that. It would just be an administrative law decision. And even that, is going to be up in the air. Another point just to throw in there is the case also involves standing on the part. Do doctors who say basically their patients might use it and might regret it. And it's really a very speculative claim that was good enough for Kaczmarek, who basically never met a pro-life argument he didn't like, but it might not be good enough for the Supreme Court. So there's a secondary issue here about whether the challengers should be there in the first place. If the court says they shouldn't be, that makes the whole case go away because there wasn't jurisdiction. So that's another way that it could go by the boards. Again, that really would say nothing about the Supreme Court's jurisprudence or trending attitudes on abortion. Okay, so big because it's abortion, big because it concerns the medication that's used in over half the abortions in the United States, but not big in the sense that it's not really about abortion, pro-life, pro-choice per se, but rather administrative law and a pretty arcane claim at that about whether the FDA had enough to go on when it expanded the use in 2016 and 2020, which expansion has proven perfectly safe and useful. There's a second important issue in the case as the Supreme Court granted it, and it would be another basis to reverse and basically make the case all go away, so mifepristone would continue to have its status as a viable and permissible drug. So that is standing. You've probably heard of that concept by now, and it basically means that you've got to have a really sort of concrete, particular injury for a federal court to grant you relief. It's not enough to just have an ideological objection. All right. The doctors who brought this claim, they are emergency room physicians. And it's clear that they are anti-choice, pro-life, and object to mifepristone, but they've tried to say, in addition, they be injured by the FDA's decision. How would they be injured? Okay, hang in there. It's basically like this. Some women out there are going to go to a provider and they're going to get mifepristone and they're going to use it. And then either they could have an extremely rare emergency situation, which, happens next to never, or they could deeply regret their decision. Anyway, let's say it's the former. They could then, instead of going to their provider, they could go to an emergency room physician. That physician would need to treat them based on the physician's responsibility. And that, in turn, would violate the physician's conscience because they are morally opposed to abortion. All right. So do you catch that sort of tinkers to Everest to chance reasoning? Some women will take it, get it from their provider, have a serious injury, not go back to their provider, go to these plaintiffs, and that would violate the plaintiff's conscience. Now, that was good enough for the Fifth Circuit, good enough for Kaczmarek. It's just to sort of state it is, I think, shows that it's not going to hold up. I think if this is where the court is focused, it's likely to say no standing. That kind of chain of speculation, this could happen, then that could happen, and then maybe this, is exactly the sort of thing that the court has said doesn't work. Rather, you need a concrete, particularized injury, these concatenation of speculative possibilities doesn't cut it. So that's going to be that's in fact the first issue that the Solicitor General has raised, and that will be a big part of the argument. And indeed, if the court finds no standing, that's it. That means there wasn't jurisdiction in the first place. Kaczmarek should have stopped right there. And we're back to the status quo ante, as the lawyers say, that everything is fine and dandy with mifepristone until the next challenge. Okay, so there you go. Those are two possible scenarios in which the court holds, basically, that mifepristone is okay as is, which I think is the likely holding here. And that will be for either standing reasons or reasons that the FDA didn't do anything wrong, didn't act arbitrarily and capriciously. And if and when that happens in June, expect the headline, Supreme Court upholds abortion, and the sort of secondary message, they're not so, anti-abortion after all, notwithstanding the decision overruling Roe v. Wade. And remember then what I'm telling you now, which is it's really not about abortion. It would be about administrative law, and standing doesn't really tell you much about where the court is or is going on actual abortion jurisprudence, which, as we know from the Fifth Circuit, even this week, continues to really pose all kinds of new issues and problems in the lower courts and the states, which is, I don't know about an irony, but is noteworthy since the court's opinion, Alito's opinion in the Dobbs case, seemed to suggest that once they overrule Roe, the decision will go back to the states. It'll be a political process, and the legal agony of the Roe age will be at an end. So very far from it. That's just a little final editorial aside. Main point is mifepristone's permissibility. It will be before the court, and the way they've granted it suggests that they have either of two ways to uphold it, and my best guess is that they will, and that should happen by June. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.